I would have told you sooner, but it just happened.
You see who we have in jail at 1 o'clock? Travis.
Thank you, Judge. You just got a job.
I know, that's what I'm gonna say.
Dang it. Okay.
Has there been any else with the other attorneys there?
I don't think so.
Okay, I'm just looking over Miss,
It's Bowie now, sir.
Miss Cole's recommendation.
When was that from, Judge?
December 21st of 2016. Oh my.
Yeah, Judge, this is a brand new motion.
Oh. Okay.
Lots of things have happened since 2016.
Oh, I didn't even, it was just when I opened up the file, that was the first thing here. So I just thought that was very recent. I didn't look at the date until you mentioned it. Okay.
No.
All right, let's go in the record then. This is case number 11PA9EJ, Raymond Community of JNS. Here in the court room, we have the father of the child, Mr. Derek Sprague. Are you Mr. Sprague here?
Mm-hmm.
And also present is Rebecca Boyd. And with her is her attorney, Rebecca Hensley, which advise both of the parties that these proceedings are being recorded by digital recording device. As such, when you speak, make sure you speak into the microphone. Do not talk over anyone else. Each of you will be given a chance to be heard. But when someone else is speaking, remain silent. When it's your turn to speak, then you can tell me what you're going to say and why you disagree with what the other person is saying. Do not interrupt me with the court or the other party. And that way we can proceed in an orderly fashion. The motion that's before the court as an order to show cause for temporary order filed by Ms. Hatfield. I'm just going to look at the affidavit in support of the motion. Let's see, changing his address. Okay, Ms. Hatfield, if I may summarize it, your client was incarcerated during that time. The father, Derek Sprague, had full placement. Since her release, he is not allowing the placement to occur between the daughter and your client. Is that a fair statement?
That is a fair statement. However, we don't believe the child actually resides with Mr. Sprague. We believe she resides with a family member of Mr. Sprague. So, but my client hasn't even been told where she is.
Oh my goodness. Mr. Sprague, you realize you have a right to be represented by lawyers.
Mm-hmm.
Is that right?
Yep.
Okay. And when you answer questions, because if we ever have to listen to the tape, when you go an M and a yes and a no can be hard to distinguish. So use the words yes or no. So, child living with you now or with someone else?
Yes, and part of the problem that makes this situation so dangerous for my child is all the hearsay that everyone seems to operate on and all the shenanigans behind the scenes. Kind of seems like it's stalking. That's not beneficial for my daughter or anyone involved. I shouldn't be hearing town gossip and stuff that people are assuming and then attacking random people because they think they can weaponize hearsay. My daughter floats between my home and my parents' home, my brothers, whoever else she deems necessary or we deem necessary. She has a very flourishing life. She's a young girl that's turning into a young adult. She lives with me wherever I go. My daughter goes unless I'm at work or she's at school pretty much. The only times we're pretty much apart is when I go and do stuff like on my own to try to have a little bit of, a life kind of thing to stretch with the stresses, and then it's right back into Mr. Mom kind of thing. What we've got going on works very well, and I do gotta say, the first words out of my mouth that I told my daughter technically should have been, whatever she wishes is what I'm here for. I'm her advocate. I'm here for her best interest, and I do want her wishes known. She says she can call whoever she wants. She knows people exist. She knows no one's stopping them. She hasn't tried to reach out to anyone on her own. She would like it if people would stop trying to force her to do things she does not want to do. She is happy where she's at, given the circumstances.
How old is your daughter, Mr. Sprague?
11.
Well,
Can I just ask a couple of questions?
Sure.
Mr. Sprague, isn't there a CHIPS case that removed this?
No, and again, more
Could you
hearsay.
please just let me finish what I'm saying? Mr. Sprague is currently charged in Langley County with felony child abuse, intentional causing harm, a couple of bail jumping, and a couple of other criminal cases. So that is one of the reasons that I was concerned that the child is not with him. The court can take judicial notice of 21 CL 353. Again, that intentionally causing harm child abuse felony charge is still pending. Generally speaking, when someone is charged with felony child abuse, any children in their home are removed.
Can I speak to that?
we need to look at that case, okay, because I'm just seeing what the bond says. Just a minute. 21 CF 353.
Yes, 21 CF 353, Judge.
Well, the first bond that was issued, this was February 28th of this year, that's a couple months ago. Says no presence in establishments with a Class B liquor license, absolute sobriety, and cooperate with Langley County Department of Social Services. Okay, then they amended that. There was, looks like they just,
They tried to railroad everything through.
just, Mr. Sprague, please, I know you want to say something, hold it in, because otherwise it gets out of hand. Then your thousands of times when you do let people speak whatever they want, then it's gonna turn into a shouting match, and it gets out of hand.
I'm just trying to
And we get it.
clarify each point.
I'll give you that opportunity. That he is indeed charged with physical abuse of a child, and for whatever reason, I don't see anything in here, unless there's a companion CHIPS case besides that, removes the child from his home.
And of course, I don't have access to a CHIPS case, so
Yeah,
I
we
assume
don't.
there is a CHIPS case out there, but without having access to that file. I don't know.
So can I speak and set this straight? Alright, this CHIPS case, this abuse case, is frivolous, and everyone involved knows that it's a dog and pony show, as I'm sure you're aware. Some of these motions in Langley County are completely baseless, but yet, in the supposed best interest of the child, they're continuing on. My attorney absolutely shredded Dan Dooley on the court stand, and John Rhodey hit his gavel and continued that there was no falsities there, and he believed his statement, even though there's nothing in his statement besides the social services statement that he read almost verbatim. He didn't witness nothing himself, but yet he was their sole testimony witness. The actual case that started this stems from mail fraud. I hold right here the copy of the letter that was placed in my mailbox. If you notice, there's no postage stamp. This person alleging to be a Langley County Department of Social Services social worker, Rachel Tulicka, put documents in my mailbox with Bruce Brown, I believe that's the first name, from Annville Police Department witnessing this. In the past, Mr. Brown has had to conduct her investigation because she wanted to rubber stamp me as aggressive. 30 minutes later, he ended up leaving, and everything was unfounded because the police officer had to do the social worker's job. So now we go to last year of October. This lady comes on my property in October, and I don't hear from her for almost months after the fact, after this court process has already started. So there's a lot of shenanigans, and then that leads up to why Ms. Hatfield was so dead set that my daughter was unsafe and she was going to get to use more of these little spells that, quite frankly, are a color of law treason against mine and my daughter's rights to our well-being. They put my family in harm. She's operating on false assumptions. I have nothing. I am a free person. I'm charged, not convicted, and I like to reiterate that because, frankly, the fact that Ms. Hatfield works with the Langley County in different capacities, and then is here in this room right now being represented by the same people and playing with the same people that she works with, I would call that a conflict of interest, and I do think that should be noted on all these further records. Ms. Hatfield's activities, biasism, misfeasance, stuff like that kind of thing. My daughter is.
You're biting off all that. Here's all, my only question is this. We're not here on the criminal case.
No, I'm just.
My only question is this. Is there any case in Chip's court or juvenile court? Is there a case pending as far as you know? Simple question, yes or no?
There's a CHIPS case, and it has nothing to do with my daughter, and my daughter has been kept out of the cannon fodder so far.
So
And
there's
I'd like
no
to
Chip's
keep that.
case that's pending that involves your daughter that's a subject to this action. Is that what you're saying?
Yes, as far as I'm aware, no.
But there is this criminal case that's pending, and they even filed an information, so that meant that they found probable cause either through a preliminary hearing or restraint, one or the other, but there is a case that's currently pending in criminal court, and you're charged with 2 counts of misdemeanor bail jumping and physical abuse of a child. The victim that is identified in this complaint, there's no name that's used, but the date of birth is May 2nd of 05. Is that your daughter?
No, that'd be my son, Matthew.
Your son, Matthew. Is the child also in your home?
No. Matthew's autistic, 15, and I took his Xbox away after 2 weeks of fighting with everyone in sight that he didn't want to work. So
It involves that child.
he ended up taking me to social services. That's
You
on
don't
the
need to
line.
expect. Now, with respect to this case, we will obviously need to appoint a guardian ad litem. Because when Ms. Cole was the GAL previously,
No, I do not wish to have her have any contact with my daughter. The circumstances leading up to this, she has showed up on my property to try to physically attack me with the court process. We need to have another unbiased guardian ad litem appointed, please.
well, typically what we do is we appoint the same guardian ad litem that we used previously.
I'm sorry, but she was involved when Becky was cooking meth in the home with my daughter present in the room. That guardian ad litem did everything in her power to try to put my daughter back with her, like for 1.5 years. I have evidence, all the documentation. I tried to put complaints in on this.
I don't even care, just any guardian ad litem, see what we're dealing with.
Normally, we stay with the same guardian ad litem, Mr.
No.
Sprague, but it's very typical, I see this 99% of the time. If the guardian ad litem gives a recommendation that one parent doesn't agree with, then all of a sudden that parent says the very same thing, just that they're biased. And the only reason is that if the guardian ad litem had gone along with what your theory was, then you would have liked it. But we're gonna appoint, Chelsea Payne as guardian ad litem. So you could get that, come up with $300.
You said that was Chelsea? The first name, Chelsea.
Chelsea Payne.
In the mean,
Each got to come up with $300. If you don't like what this latest recommendation is, I'm sorry, but then we're not gonna be changing, you understand, right? Let me finish, right? That's what we're gonna do. In the meantime, we've got an issue as to what, placement that the mother will have. She's the mother, and she's a parent. She's a parent just like you're a parent, right? And so, and I'll be honest, I've been doing this 40 years. I've never seen this once happen where a parent was denied placement privileges of the child, because in order to do that, you've got to prove that non-releasable child, which is the highest form, that for the other parent to exercise placement would cause the child severe emotional, physical, or psychological harm, and you have to prove that by producing an expert, a psychologist, a mental health therapist, or somebody else to perform. If you don't figure this out, I'm afraid that that's very good. So we need to have some contact between the mother and child and Ms. Hatfield. How was the basis the mother is also her child?
Thank you, Judge. In November 2018, Ms. Foley was arrested and subsequently incarcerated. Since November of 18, she's not seen the child once, so almost 4 years.
She's 11 years old, right? So, she hasn't seen her since that's like 4 years, right?
Almost.
My concern would be whether or not a sudden, unannounced interaction might be traumatic for the child. So what I'm suggesting is we appoint Ms. Payant immediately. I'm relatively confident that Ms. Payant is, if I'm going to call her on the phone right now to see if we can get a hold of her. And what I would like to have is I would like Ms. Payant to have an interview with the child to make sure that the child, and then let Ms. Payant give us at least a preliminary, it might be a gradual contact, you know how we do these things. What we're talking about is whenever a parent hasn't seen their child for a long time, again, our motive and our goal is the best interest of the child, right? So, my concern is that to say all of a sudden, after not having seen your mother for 4 years, the kid is dropped out at the mother's doorstep, that might be traumatic for the child. It may be something that she would be ecstatically happy about. It may be something that may be terrifying for her. I don't know, and we cannot interview her. And it's also we have to deal with the guardian ad litem. So what I'm going to do is I'm going to appoint the guardian ad litem, and in fact, what I'm going to do is, before I do so, Mr. Springfield, how soon do you think you can come up with the $300 to pay for the accountability for the guardian ad litem fee? Do you have that ability to do that relatively soon?
yeah, I could do it within like 30 days. The longest I can take, to be very quite honest, because this is yet another frivolous matter, and as it's been stated, I have a lot on my plate. I'm kind of stretched pretty thin. So if I could have the 30 days that's allotted to me, I'm good.
Well, what I'm going to do is this. I'm going to order you to pay your $30 in 30 days. I'm going to ask the payment to start upon the post of yours, okay?
Which will be today, Judge.
Which will be today. But you can do this today. And what we will do is we'll have another hearing a week from today. Regarding the land recommendation. And what I am also going to direct them to do is to pay, to contact Mr. Slade. You have to contact Ms. Payne. I'm going to give you her phone number to make an appointment so that your daughter can visit with the guardian ad litem. And if she gets the recommendation next Thursday, we'll have it prepared to start whatever recommendation she gives. Will be implemented on a temporary basis.
So what are we going to do if things go south and my daughter decides she can't handle what's being forced upon her?
That's why we have a guardian ad litem.
Is the guardian ad litem gonna? I wasn't done though. What's gonna happen when this is done and my daughter decides that she's not safe where she's at and she feels helpless and she starts taking drastic actions? I've had one child that's running away already. I know how that operates, and I know how social services function. It's gonna be uneventful, and it's gonna be even more traumatic to force my daughter in a room with her at social services. The contact for the reintegration with my daughter, the reintegration and the forced contact that's gonna be ordered with her and my daughter is gonna be supervised, right? She's not just gonna get to have my daughter back in her home.
Shut the door, and the parent has replacement. Those are the things that you, the advocate, need to do. And again, you can't do it by saying, well, I believe that my daughter is something emotional, and it has to be done by a professional. If that was the standard, then this would be happening quite frequently. And again, each parent has parental rights, and your daughter has the right to have a meaningful relationship with both her parents.
That she wants, and she chooses not to.
She's 11 years old.
Yep.
She's
Traumatic. She makes her own decision.
So that if she made the decision that she didn't want to go to school anymore.
So it's not traumatic to force her into contact with someone?
Her mother, not someone, her mother.
Could we instruct counsel not to talk with me, please? I'd like contempt order, please.
Could you ask Mr. Sprague to just shut up?
This is a question for Chelsea. Chelsea, this is the court commissioner calling. How are you doing? Okay, fine. We're in court right now, and we have a case in which we need an immediate guardian ad litem. And your name was the first name that popped in my head. And the clients, the parties rather, are the person by the name of Derek Sprague, and the mother is. Her name is Bowie. What's your first name, ma'am?
Rebecca.
Rebecca Bowie.
It was Thurber.
Her previous name was Thurber. And neither one of them had any contact with Miss Payne?
I have it.
Mr. Sprague?
Not that I'm aware of.
So this is what we've got. I'm just doing this over the mother has not had contact with the child since November of 2018. She went to prison, and the placement was with the family. And the mother is requesting that there be contact. My concern is that the mother has not had contact with the child. The child was born on May 2nd of 2005, so the child's 11 years old.
Sorry,
what I need
you had the
is
birthday wrong.
for you to have some contact with the child and suggest in a week or so, some kind of very modified temporary placement. But I'm just concerned about whether the child will be traumatized by that, so that's what we need to know there. Can you give me? Hold on. Mr. Sprague, is the child currently seeing a therapist or a counselor?
No.
No. Okay, so I'm gonna give you your phone number to both of the parties, and the order that I have won't be coming out until, next week, because, Jane is, on spring break, she won't be back until Monday. I'm not gonna be here till Wednesday, when I'll start it, okay? But you can start working, the mother's gonna post $300, the father in the order's gonna have his $300 within 30 days. The mother's gonna bring you $300 today. Okay? So if you make some notes, and so that, and I'm gonna give them your phone number, and then you can make some, then we're gonna, you could just do a quick, phone conference, and we'll schedule sometime next Thursday. Okay? Okay, wait, before we leave you.
My client lives in Arkdale, it's a couple hours away. Does Ms. Pant have any time available to see her today, perchance?
Yeah, do you have any time to see Ms. Bowie today, because she lives, some distance away? Okay. You want to give her a time, or? Okay. Okay, so she's available at 1.
That's
Okay,
fine,
she'll be
Judge.
there
She'll be
at
there.
1 o'clock, okay? Okay, bye-bye. Okay, that was, worked out well. All right, so we're going to appoint Ms. Payette as guardian, and again, she is going to be the advocate for the child, Mr. Sprague. Now, just to let you know, the guardian ad litem, you've been through this before, so maybe I'm preaching to the choir, but when we look at custodial decisions, the first consideration we have to take into account are the wishes of the parents, which oftentimes are not valued because each parent wants something different. The second most important consideration is the wishes of the child, as those wishes are expressed through the guardian ad litem. So the guardian ad litem's recommendation carries a considerable degree of weight. Is the alternative? No. Otherwise, the GAL would be like the judge. But whatever the guardian ad litem recommends carries a great deal of weight. All right, so that's what we're going to do. We're going to appoint the GAL. The owner won't be going out till probably next Wednesday when the judicial system will be back. But it will say that each of you got to post $300. You got to do what's in there. Mr. State will be given 30 days to do it. And when the decision is for hearing next Thursday, you look at my calendar. I know Ms. Jackson, you're going to be there all day, right?
I have an 8:30 with you, Judge, and also at 9 o'clock, and then I'm in front of the judge upstairs
31st, right?
from 9:30 for a while.
8:30, 9:30. I'm good from about 10 to 11.
Like 9 o'clock would work for me.
Well, I got a hearing at 9 o'clock. I got a hearing at 8:30 to 9, a hearing from 9 to 9:30, and then a hearing from 11 to 11 and 10. So I got the 10 o'clock time available.
10 o'clock,
I
huh?
could probably do, Judge, I'm in front of Judge Kowalski, Judge
Brody?
Brody at that time.
I could probably be there by 11:30. Does that work for you?
We could do it 11:30.
I would like 11, or, I would like
Well,
sooner.
if the attorney's in court, sir, I mean, I can't force you to put court system. So we could do this at 11:30, or we could do it at 1 o'clock.
So how does it work when an attorney's someone with how does it work when someone's affiliated with the county? There's no conflict of interest or no recusal that needs to be made? Something an attorney would bring up?
Conflict of interest, that would be, it's also if you're not doing any cases in Hillsborough County, I'm afraid that if she's got personal knowledge of like if she had previously represented you,
She has.
she's represented you.
Oh, she has, and I got rid of her quick.
For what?
here. What's up there?
My memory might be a little fuzzy, but I'm pretty sure that she was an attorney on one of my custody cases that went out through because it involved me having to straighten
I
out.
have no idea. So I'm.
Again, there's a lot of conflicts of interest.
I'm not going to kick her off the case unless you come in with something specific.
It will be. It'll be
You
substantiated.
know, we can, the professional code to see what a conflict of interest is.
I know what a conflict
And,
is.
you can find out. All right, so we're gonna do this at 11:40. Okay, now I know. So 11:30 on April 26th, right? And then regarding the item, I don't know if the code will be available, if that you can just submit a letter, and that's gonna be the, Ms. Bennett knows what the law is, and strongly encouraging Mr. Spade to get an attorney.
Oh, I have an attorney, and this is going to get drug out because anything done here is going to be undone when my daughter turns 12. So yet again, I have to waste more money because this person knows what's out for my past.
Well, it does not mean we get to make our own decisions, Mr.
Okay, so we are.
When can we have contempt of court for the person that keeps talking to me, aggravating?
I was just trying to explain to Mr. Sprague that as well,
Thank you.
although many people feel that that's some magic number, under the laws of state of Wisconsin, it is not.
That's what we were referring to, there is no magical age, it's a thing that you take just to make that decision.
Nope, but I know medical evaluation of therapist definitely holds more weight than maybe an attorney.
All right, so, we'll be adjourned until 11:30.